right, so good morning,
Kelly.
welcome back. How's everybody doing? So I got good news. Do you want it now or at the end of class?
Now.
Here's what relate to. Well, the overwhelming majority said now. Well, it's bad news for me, good news for you. So good news is we don't have class tomorrow. Yay. Bad news is I have to go all the way to stupid St. Louis to have a medical procedure. So I'm like, boo, exactly. So with that being said, I will send out an email to tell you, I'm going to show you how to use this online system. I'm going to do some online office hours. And of course you can email me, it just needs to be after like Thursday on, because I want to make sure I'm not like loopy and I'm saying something weird and embarrass myself. So please don't tempt me, because I'll want to respond. Another important thing, Dean Colin is, I don't usually call him, go to his last name, so I didn't think about it, but Colin is very interested in increasing the number of online classes you can take. Essentially what's happened is the American Bar Association has now said that law schools can offer up to 30 hours of online classes. Before it was up to 15 hours, so they've essentially doubled it. There's a growing trend, there's a lot of law schools, one of them is John Marshall Law School in Chicago, have complete online law programs. And it's just trying to accommodate people that work, have families, or just, don't necessarily want to participate in the traditional environment. But that being said, at some point in time, I don't know when, I'm going to teach one of our courses online. It has to be sometime before February 18th because I'm supposed to get your feedback, meaning I'll hand out a survey, and then I have to share that with the faculty when they vote. No pressure. So decide the fate of the law school. So I need to show you how to use the software. If we have any snow days, I will use the software because I tried to the best extent possible to not reschedule class because it's really a pain trying to find the time that everybody's schedule can accommodate. So snow days I'll always use this system. So I'm going to show you how it works. If you're on your laptops and you want to try it on your own and see what it looks like, no worries. Feel free. So basically you just log into your Blackboard class website. And so mine's going to look like the faculty version, but it's pretty similar to yours. So I'm going to click on Civil Procedure. And you scroll down to Tools. Do you all have Tools on yours?
Yes.
Awesome. Scroll down to Tools. Ooh, back. I didn't want to do that. Let me try again. I apologize. You scroll down to, Course Tools. This might look different. And then you click on Blackboard Collaborate. So it's going to be called Blackboard Collaborate. Clicking on Blackboard, and there'll be a session. I created a sample one just to give you an idea. It'll say online class and the date when we actually do it. So you click on that class and just basically join the room. This particular computer I see does not have, how convenient. It's not downloaded on here, but essentially what will pop up, what you should see on your screen, if you don't have your laptop, if you can look at your neighbor, the software is not on this computer, is a box with a video in it. Who can see it on their laptop? No one can see it?
It's not downloaded.
Yeah.
Say it again? Oh, you all have to download launcher. Okay, so we'll try it again. But essentially when you download the launcher, hit join session, it just looks, there's a big video box. My lovely face will be in the box. It has your names listed on the left, and there's just icons that say raise your hand. It's a hand, so it's like I have a question. And you can click the video option where people can see your face, or the no video option if you're in your pajamas. We don't really want to see you. So, but I'm being joking around. But seriously, so that's it. You just raise your hand. You click the hand button if you have a question. And then there's just a microphone you click. And so maybe it'd be helpful if I give everybody a chance to download whatever it's called, what do they call it? The software. And then I'll maybe do a random trial session, meaning I'll leave the class window up and sit on and basically be online while I'm working. You can log in and make sure that it works for you. And if there's a problem, let me know. That's probably the best way. But I at least want to show you how to get to the Blackboard Collaborate. Alrighty. In the way that it works too, like if I don't want my face to be there, I usually try to use PowerPoint slides if I'm teaching online. So you'll see the slides say, you know, here are the facts, here are this, here are that. And I also typically, with an online class, will email you the night before to say, hey, you're my attorneys for the day. This is what I'd like you to be able to argue. Argue Brennan's side, you have O'Connor's side. So with the online class, I'll give you a heads up. Okay? All right. So let's get out of here real quick. You guys are making me feel like I'm at a funeral of somebody who doesn't have any friends. It's feeling a little heavy. Are we tired? Because I am, but I'm still like peppy. What's going on?
It's Monday.
And I don't drink coffee, so I just don't have an excuse. I love coffee. And I used to drink it. I just can't drink it anymore, but I live for coffee and lattes. All right. Let's get started. Are we ready to rumble? Yay. All right, so our two attorneys for the day. We have Attorney Walls. Where art thou? Hi. Gave me the friendly wave. And I'm going to do 3 today just because the Castro case is really long. It's kind of ridiculous. Does anyone want to volunteer for today?
I volunteer as tribute.
All right, Jessica. Remind me your last name, Jessica.
Harper. It's literally one letter different from hers.
Okay. Walls. And we need some male influence here. Attorney Blank, where art thou? All right. You get a good day, you got 3 people with you, and 1 volunteer, so they're definitely prepared. All right, so from the last class, we ended discussing the Burger King case, right? And just to remind you of the black letter law from the Burger King case and make sure you remember it, essentially what that court was saying is that although the existence of a contract by itself may not be sufficient to support personal jurisdiction over a non-resident defendant, when analyzing minimum contacts in a contractual situation, the court will look at the defendant's contact with the state during the negotiation of that contract. They'll look at the terms of that contract and the actions taken by the defendant while performing the contract in that state. So anytime you see a fact pattern that has a contract involved, you're going to remember the Burger King case and you're going to look at, well, where were the negotiations made? You know, how much interaction in terms of the terms of the contract require them to be in a certain state. So you're going to look at anything that will support asserting personal jurisdiction over the person. So, but you're looking at the actual contract dealings. How long is the contract? Is it a 20-year contract like we saw in Burger King, or short term? You know, if it's long term, you can say, you can anticipate at some point in time during 20 years that there might be a legal dispute that might come up that might require you to travel to that state where the contract was entered to defend yourself. So again, it's just creative lawyering. You're looking at the facts surrounding the formation of the contract to see if you can make the argument that it's fair for that person to defend themselves in whatever state the plaintiff is trying to bring the lawsuit. So just if you see a contract. If not, we go back to our specific and general jurisdiction. So before I talk about the internet case, I want to just remind you, just as a refresher, where we are now is we are almost done. After general jurisdiction, we're done with personal jurisdiction. So this is the hardest part of the semester. And again, what we're trying to decide is to file a case in federal court, we need to know that there is personal jurisdiction, subject matter jurisdiction, venue, and proper service of notice, meaning notifying the defendant that there's a lawsuit against them. We're just focusing on personal jurisdiction. So what we know as of today is that there are several pathways to achieving personal jurisdiction. We know that you can achieve it through general jurisdiction. We know you can establish personal jurisdiction through specific jurisdiction, and we know there's those 2 territorial jurisdictions, which are in rem and quasi in rem. If we satisfy any of those, voila, we've got personal jurisdiction, okay? All right. So the Pavlovich case, 2002, I'll take it, it's not the 1800s. Which one of our kind attorneys, Harper, Walls, or, and I'll grab your question, hold on. Where did I put blank? That was it. Okay, yes, where are you? Someone said it. Who sent that a question? I imagined that, wow. Voices in my head. Okay, yes, facts, thanks.
I'll go first.
Thank you.
Defendant Pavlovich is a resident of Texas. He's the president of Media Driver LLC, consulting in Texas there. He lived there several years, but before that, he was in Indiana studying at Purdue University. He was a systems and network administrator there. He's never worked in California, but he is being sued by a company in California for copyright infringement.
Excellent job. So that was like textbook perfect facts. Why? He didn't go trying to talk about the arguments. He's not into the holding. He's not running through the whole case. He's giving us just what we want to consider at this point. Great job, Attorney Blank, which is just the facts. So for the people on this side of the room, I'm just going to repeat what he said just a little bit louder to make sure we're all on the same page. So we know, as he said, engineering student. He's super smart. He's a hacker. I like this kid, right? He studied at Purdue. I think hackers are cool as long as they don't hurt anybody. Do you all remember that music? Oh, you might be too young, but the music, it wasn't, it's not Spotify. Napster. Wasn't Napster freaking Rockstar? I still have music on my laptop from Napster before they shut it all down. I love Napster. Okay, sorry. But that's the kind of hackers. I'm like, they've got plenty of money. I shouldn't say that, but I'm like, give us a little music. We're struggling, you know, multi-billion-dollar company. But yeah, so I think he's cool. So we know that he's an engineering student, hacker, studying at Purdue. While he was there, he designed this Rockstar program that disabled the anti-copying devices on standard DVDs. This is great. When I'm in LA, I've always, and I'm not ashamed, there's a certain street off the 101 freeway you can go and buy DVDs that people have used this anti-copying disablement to make and it's like the movies that are in the theater, like that are from the studios, Warner Brothers. So like whatever is in the theater now, you can buy them for $5, and I love it, and I don't feel bad about it.
I have a DVD guy here if you want.
That does it? Yeah.
Well, he sells.
You know, it's all, what kills me is that, so when I'm in Florida, they have what they call flea markets. In California, they call them swap meets. And, you know, it's people selling odds and ends, but they're selling these CDs, and I'm like, why are the police like, this is illegal, copyright infringement. I guess they have bigger fish to fry, but I'm always entertained by their boldness in selling illegal movies. So we know he created this anti-copying software, works on standard DVDs, thus enabling widespread piracy. So this is not a good thing. Pavlovich posted that software on a website. He's totally gung-ho, which he allowed free access. Okay, so he's just, like I said, trying to help. He's like Robin Hood. We like him. So Plaintiff is a nonprofit trade association, sues Pavlovich in California. As Attorney Blank said, when the lawsuit was filed, Pavlovich had already moved to Texas. And the reason they picked California is why? Why do you think they picked California, Attorney Blank?
That's where the recording industry is.
Yeah, so the recording industry's there, and don't forget Silicon Valley, Apple, all the tech companies. So if you're gonna get a favorable jury, you wanna do California. You want these tech companies to say, yo, we gotta shut down, we gotta come down hard on people that are creating software that's taking money away from our businesses. So they strategically picked California for those reasons. Pavlovich was pretty innovative. He found an attorney, which I'm impressed, in Silicon Valley that is willing to represent him pro bono for free, and fought the plaintiff all the way up to the California Supreme Court. So they went all the way. What was the defendant Pavlovich's argument, either Attorney Harper or Walls? What was Pavlovich's argument? Defendants.
That he never availed himself in California.
Okay, what do you mean by avail himself? I mean, you're right, I just want you to give us a little bit more.
That he had only just posted something on the internet, and so that he hadn't given him any reason to exercise jurisdiction over him.
Okay, so he hasn't, you're giving me great stuff, he hasn't posted anything on the internet, he didn't purposely avail himself. How did he not purposely avail himself? What was missing there? Like, do you remember from International Shoe what counts as purposeful availment? Actually, that was after then, the Hansen case. But what would it look like if he had purposely availed himself?
Do you mean that, like, he didn't do anything purposefully to direct anything towards that forum or venue?
Excellent, yeah, so no solicitation. So I think he has a very, very strong argument here. Great job. He's saying, look, my argument is really simple. I don't have any contacts with California. I haven't solicited to get business in California. Therefore, there's no personal jurisdiction. He's like, I don't have any offices in California. I don't have any contacts in California, no bank accounts. There's no personal jurisdiction. So he's saying, look, this is a really clear-cut case, which I think is a strong argument. But what was the plaintiff's argument, the flip side? Attorney Harper, what was the plaintiff's argument? What's the plaintiff's argument?
Sorry, I'm trying to find it.
Okay.
They argued that basically because he posted it to a site that could be viewed in any state, that was enough for purposeful availment.
Excellent. All right. So, what else did they say, Attorney Harper? I keep messing up your name, and I apologize. What analogy did they make about liable? What analogy? And feel free to the other attorneys to jump in. What analogy did they make about to analogize Pavlovich's actions as an out-of-state person? And he said, oh, we have a similar example having to do with libel. Go ahead.
There was that National Enquirer that published an article about an actress that lived in Hollywood, but the article was published in Florida. They found that it was reasonable to think that the fallout could reach the actress in California, so that they had personally availed themselves to.
Excellent. Do you agree with that analogy, that it's reasonable to foresee that even though the article was written in Florida, that would impact her industry, her job,
Yeah.
her livelihood? I agree as well. All right, so the court analogized Pavlovich's actions to that of an out-of-state publisher who writes a libels article, as he referenced, about someone located in, say, California. The knowledge that the harm would have an effect on the plaintiff's home state is enough to establish personal jurisdiction. And the court was referencing the Jones v. Calder case, right, and other similar liable cases. So we know that we have, obviously, an issue of personal jurisdiction, as we do with every case in this section. What's the first thing you do when you have a personal jurisdiction problem? First thing you do is try to establish what type of jurisdiction. Is this specific jurisdiction, general, in rem, quasi-in rem? There's going to be a fifth one we're going to add, and then we're done, which we haven't learned that yet. But there's something that we're going to discuss a little bit later, but essentially there's two steps to establishing personal jurisdiction. Oh, of course it doesn't work. Okay, so we have statutory authorization, and we have constitutional. That's a 2. Analysis. All right, so all that means is that, and again, we'll actually do cases on this, but for the purposes of understanding, for the purpose of understanding this particular case. So the statutory authorization, all 50 states have what they call long-arm statutes, right? And so Kentucky has a long-arm statute, California has a long-arm statute. They all do. And so first you look and say, I need to determine if there's personal jurisdiction in Kentucky. So I'm going to look and see what Kentucky's long-arm statute is. And the long-arm statute says if one of these things are present, you can make an out-of-state defendant come to Kentucky and defend themselves. They'll have things like conducted business in the state of Kentucky, entered into a contract in the state of Kentucky. So every statute will have those things listed. And so you make sure that those things, they qualify for the statutory authorization. And you say, yes, that works. They have, it says if they do business here, well, they entered into a contract in the state of Kentucky, I have satisfied the statutory authorization. Then you do the constitutional analysis, and that's when you ask yourself, is it fair? And you determine if it's fair based on the due process clause by determining if there's general jurisdiction, specific jurisdiction, quasi-in rem, and so on. So it's just a two-step process to determining personal jurisdiction. We will spend more time on the statutory authorization step, but again, it's just based on a long-arm statute. So if you're practicing in Kentucky and you're trying to bring a suit against someone in Indiana, you're going to look up, just Google Indiana's long-arm statute, and it's going to tell you whether or not, what the criteria is to bring that lawsuit in Indiana. Any questions about this before I move forward? Yes?
So are both steps required regardless of whether there's statutory authorization or not?
I'm sorry, I don't understand your question. Are both of these required? Both steps are required to establish personal jurisdiction. Is that answer?
I think so, yes.
You sure?
Yes.
Okay. So again, Jessica, it's just, you look and see, oh, I have to do a statutory authorization. Let me look up that state's long-arm statute and see if the defendant's actions are listed as one of the things that qualify for statutory authorization. Yes, they conduct business in the state. And then your second step is to do what we're doing, what type of personal jurisdiction. Okay. So, moving forward. All right, so since we know we have to look at both the statutory and constitutional authority, we first look to see what California's long-arm statute says. I think it's on page 119, but don't quote me on it. Last paragraph. So California's long-arm statutes is one of the cool ones that basically just says, courts may exercise personal jurisdiction on any basis consistent with the Constitution of California and the United States. So some states, unlike Kentucky, that's all they say. So you know what that means? Yay. Satisfied. So you just go directly to this. If it lists items that have to be met, like Kentucky's long-arm statute, then you have to say, oh, they conduct business here, or yes, they entered into a contract in Kentucky. So it's either going to list, the long-arm statute is either going to list what criteria you need to satisfy to meet that state's long-arm statute, or it'll be like California's and just say, look, as long as it meets the constitutional standards, that's good enough for us. We like California. They don't make us do that extra step. We love those kind of states, okay? We like them. Illinois is another one that lists them all. And we'll spend a whole class on it and look at different long-arm statutes, but I just need you to understand it for this case. So, what does that mean in terms of analysis of personal jurisdiction? It just means you just have to use the international shoe test. You don't have to do a statutory analysis because they said as long as it complies with the Constitution, that's good enough for the state of California. So here you're going to use the specific jurisdiction test. So you're going to look at minimum context plus fairness plus purposeful availment and the factors that we discussed on fairness from the Burger King case, those 5 fairness factors. So the court then, in this case, discusses the Jones v. Calder case that we were talking about a little earlier. And again, as your colleague stated, the Jones v. Calder case, essentially there's a reporter in Florida who wrote an article for the National Enquirer about Shirley Jones, a well-known actress who lived and worked in California. The president and editor of the magazine reviewed and approved the article, and the article was published. So Jones sued the reporter and the editor for libel in the state of California. The defendants moved to have the case dismissed because they said there was lack of service of process, meaning they weren't properly notified that there was even a lawsuit against them, and they said the defendant doesn't have any minimum contacts with California. We wrote the article in Florida. So the court in that case references what we care about for our rule of law, which is the effects test. That's why we're reading this case, the effects test. So the court mentions the effects test in the Jones v. Calder case that was used for determining whether there's purposeful availment in the context of defamation, because these are defamation fact patterns that we're dealing with. So again, the court mentions in the Jones v. Calder case the effect test, and that's what they use for determining purposeful availment in a defamation case. So essentially what they said, and I'm just going to read it straight from the textbook, a state can exercise jurisdiction over individual defendants based on the effects that their out-of-state conduct had on the state that is seeking to exercise jurisdiction. So again, what is the effect test? Essentially, a state can exercise jurisdiction over the individual defendants. So a state can exercise jurisdiction over the individual defendants. Some people are writing. Based on the effects that their out-of-state conduct had on the state that is seeking to exercise jurisdiction. All right, one last time. A state can exercise jurisdiction over the individual defendants based on the effects that their out-of-state conduct had on the state that is seeking to exercise jurisdiction. So the holding in that Jones v. Calder case that they're referencing in our case is that the Supreme Court in the Jones case disagreed with the defendants and held that California could exercise personal jurisdiction based on the effects test of their Florida conduct in California. The court noted that the individual defendants again wrote or edited an article that they knew would have potentially devastating impact upon Jones, and they knew that the brunt of that injury would be felt in California, where the movie industry is, where she lives and works. And it's also, the court noted in that Jones v. Calder case, is that California is where the National Enquirer has their largest circulation. So they said, look, it's reasonable that they should have known that, although the article again was published in Florida, that it would have a devastating impact on Jones in California. And so what the court is trying to do in this case is basically figure out how the effects test that we just covered from Calder can be applied in an internet scenario. So again, they're borrowing a test that's used for defamation cases and saying, you know, we don't currently have a test to evaluate when personal jurisdiction can be asserted in an internet scenario. So we think that this case from the defamation context would be a great test. So they're trying to figure out how to apply it in this situation. So the Pavlovich court gets some guidance from holdings in other cases and essentially come up with this sliding scale analysis, which is what you will use as attorneys when you leave this beautiful law school. And so the court mentions using a sliding scale analysis for internet cases, I believe on page 120, fifth paragraph. And essentially what they say is at the end of one scale are situations where defendant clearly does business over the internet. So you've got these two extremes, sliding scale. So at one end is a situation where the defendant clearly does business over the internet, Amazon, right? If the defendant enters into contracts with residents of foreign jurisdictions, meaning outside their state, that involve the knowing repeated transmission of files over the internet, personal jurisdiction is proper. So I'm going to say that again because what this means is this is how you determine with the website or internet scenario whether or not a particular state has personal jurisdiction over that internet creator, meaning